All rise. We will obey. Please be seated.
Thank you very much. Welcome back, everyone. Witness, welcome back. Before we proceed to matters, one, the interpreters and court reporters have expressed concern that the pace of the exchange has been more rapid than it should be for their purposes. So let's watch that. Witness the warning, or rather the advisory given to you the first time and repeated often. We want to reiterate, please observe that pause between completion of the question and your commencement of your answer. And also, remember, it's 5 seconds. Try and observe that. Watch the pace. Do not speak too fast. That goes for Mr. Steinberg as well.
Many thanks from the interpreters and court reporters.
Concerns our schedule for Thursday. As I indicated earlier, we will yield the courtroom for the Ntanganda case, inevitably, because Judge Fremer is the presiding judge in that case, so he cannot be in two cases at once. So we will yield the morning of Thursday, and to make up for the lost time, we will. The proposal is to start at 2 p.m. on Thursday for 2 sessions of 2 hours with a 30-minute break in between. That means we will start at 2 and go to 4 p.m. Take a break then, return at 4:30 and continue to 6 p.m. There's something wrong with that mathematics, but you've got the point. We start at 2 and stop at 6. That's I take it there is no serious inconvenience to counsel. I see Mr. Khan indicates it's fine with him. Mr. Kinkatwa?
It's fine with me.
All right. Then, Mr. Prosecutor?
We're available, Your Honor.
Thank you very much. And Mr. Naratan, thank you.
Yes,
so that is what we will do on Thursday. With those announcements out of the way, Mr. Steinberg, please continue with your now cross-examination of your witness, and you will go until...
I hope to finish by the luncheon adjournment, Your Honours.
Thank you.
Plan. Your Honours, perhaps I can just observe that to date there have been no interventions from the Rule 74 Council relating to dealing with matters in private session. But I would alert him to the fact that during the course of this session, I do intend to deal with matters which might touch on the issue of self-incrimination. I will signal it before I pose any such question.
Mr. Mutai, that basically Mr. Steinberg is putting you on notice that there is questioning from now on may touch on matters of self-incrimination, so you'll be on alert, and that's why you've been retained to be on hand for the testimony of the witness. In the meantime, I noticed that you had indicated earlier that you wished to express some concern about the manner in which Mr. Steinberg had conducted his questioning yesterday, and you said that if you saw no need to press that concern, you would let matters lie. I take it that has remained the case so far.
That is so, Mr. President.
All right. Thank you. So we will continue.
Thank you, Your Honours. Mr. Witness, good afternoon.
Good afternoon.
Now, you've told the court in some detail over the course of the last 3 days regarding inducements that had been offered to you for the purposes of fixing the two accused, and about discussions that were had about the evidence you should give to the investigators to fix those accused. Correct?
Yes.
Besides being requested to give evidence implicating, or falsely implicating, as you say, the two accused in the post-election violence, have any of the investigators of the OTP requested you to give any other false evidence or false reports?
I don't remember.
Is this not something you would remember if it had happened, Mr. Witness? If an investigator had asked you to lie about something else besides what's contained in your first statement?
You know, the conduct has been quite for some time, so I may not remember everything that took place.
I see. Can you recall having made reports to investigators relating to issues of witness interference, witness tampering?
Maybe, prosecutor, you can refresh my mind.
All right, I'll come to that. But let me ask you one more introductory question. Besides the investigators whom you say spoke to you at the screening and asked you to fix the accused, and besides the investigators who met with you on the 6th and you say asked you to fix the accused, can you recall whether there were any other investigators or any other persons from the OTP who had induced you to give false evidence?
I remember meeting some 2 investigators in the nearby country, sometimes back last year.
Yes, and what happened with those 2 investigators? Anything you need to tell the court about?
Yeah, they asked me some questions.
Okay. And did you answer those questions truthfully?
Yeah, some were true, some were not true.
And to the extent that you may have given answers that were not true, why did you do that?
Yes, prior to me going to meet the 2 investigators, we were still communicating with my mentor, and my mentor, I mean the lady who recruited me. So she had some issues. She was telling me that she wasn't happy on the way she was being treated by the OTP. And again, she was telling me that if you want certain measures or certain goodies to be given to you, when you meet the team, you must mention some people whom she gave me the names that those people had been adversely mentioned in interfering with the witnesses.
I see. And perhaps before I ask you who those people are, I should ask to go into private session because I'm not sure what the answer might be.
For how long?
Your Honours, for just a couple of questions, but the time is approaching where we might have to go into private session for longer purposes for issues relating to Rule 74.
Private session.
We are in open session, Mr. President.
All right. Before you proceed, Mr. Steinberg, one second. Witness, we will have the court officer have you step out for a minute in the ante room. Just for a minute, we want to have some small legal discussion amongst the lawyers and the judges.
Mr. President, the witness has been escorted out of the transmission room.
Thank you very much. Mrs. Steinberg, this witness was brought to the court, and from the beginning he said that the statement he gave a statement to the prosecutor implicating the accused persons. And then he said he subsequently resiled his statement, saying that part of what he said in the statement was true, others not. On the basis of that, we have proceeded, and the standby counsel had been appointed. What is it about Rule 74 that has become so special in your question?
Your Honours, I seek by reference to this statement to demonstrate that the witness, during the course of these proceedings, has been in contact with persons whom the prosecution against whom the prosecution submits there is evidence of being involved in witness tampering. We submit that this evidence is relevant to determine why his version has suddenly changed, has changed between the time he gave his original affidavits and the time he deposed to his original statements and the time he deposed to his affidavit in July. It will also be relevant, Your Honours, we will submit to the court's assessment of the credibility of the version given in his latest affidavit versus the evidence given in his original statements, should the Chamber ultimately agree that those statements may be admitted. We submit that it is most efficient to allow the prosecution to examine all of this evidence at the moment, rather than to have to recall the witness at a subsequent date to testify on these issues, should the issue of the credibility of his original version become an issue. But in the main part, the the prosecution submits that all of this will be relevant to his credibility. In the course of this, the witness gives evidence of the fact that he was approached by certain of the alleged tamperers, and on behalf of those tamperers conveyed messages to another witness, being, are we in open session? Yes. The lady who has been mentioned earlier. And in the course of this, he may have implicated himself in offences under Article 17.
Was that not covered in the guarantees given the witness earlier, that whatever he said may not be used against him in any directly or indirectly, in any subsequent prosecution against him or any such effort, with the exception of 70 sub 1A and B that pertain to giving the court false testimony while on the stand?
Your Honours, indeed it was, but the undertaking is an undertaking of the OTP in this court. No undertaking that this prosecution gives can be binding on, for instance, the Kenyan government. So there is a combination of protection offered by Rule 74, and the combination is an undertaking that the prosecution should not use this evidence to prosecute the witness, but also that the information should not be disclosed publicly, including to other authorities who might wish to use the information. Now, we're in public session at the moment. I don't want to say too much more, but the point is that evidence that might incriminate the witness should be given in private session and should be subsequently placed under seal by the chamber.
All right. We don't need to have any extended debate on that. We just wanted to know the direction of the prosecutor's questioning and why he posted that signed post to this part of his questioning. The witness may be brought back here.
Mr. President, I'm not going to address the article of the issue of 74, given Your Honour's ruling on the issue. I would say that, given my learned friend's Breyer submission, in my respectful submission, and it's a strongly held position, before we get into that, there is an ethical obligation on the prosecution to seek to controvert the initial account of the witness, by objective evidence or otherwise. Your Honour, there's been no attempt by my learned friend, despite all these submissions of declaring the witness hostile, to even attempt to do that. We're dealing with a by-alley of allegations, and this assertion the learned friend has said now, we are getting more and more tenuous arguments, we say, from the prosecution. Your Honour, that can be put. It can be put at the proper time, but surely there's an obligation first to deal with the veracity of the original account. And the prosecution, who've been investigating this case for 4 years, surely we say they must have some objective evidence to show that the first account was true and not a pack of lies, as the witness says. And that should be done before we go on to this sideshow that the prosecution are trying to put centre stage. Your Honour, there's been no attempt by the prosecution to do it. We say it's necessary.
Well, Mr. Ken, we will not engage in that debate at this time. We believe that it is a matter upon which you can make submissions at the right time.
Your Honour, I'm grateful. The only reason I raised it, my learned friend said he had a very smoking gun, and I'm yet to see a whisper of smoke.
I'm sure you'll be sitting by waiting for it.
Eagerly.
We will now bring back the witness and continue.
And Mr. President, I'm grateful to my learned friend. I think a wrong reference was given, just for the record. It's in fact the correct reference, I'm told by my learned friend, is Ken OTP 0117-1019. My learned friend is Mr. Hooper.
That is what we have at tab 38.
On the transcript, it was wrong. That was my point.
Mr. President, the witness is back in the transmission room.
Thank you very much. Witness, we just had a little discussion with the lawyers about the procedural matter, and Mr. Steinberg will continue his questions of you. Welcome back. Mr. Steinberg.
Thank you, Your Honours. I just need to find my train of thought again. So, Mr. Witness, you told the Chamber that prior to meeting with the OTP investigators, or with two OTP investigators in November 2013, you had certain discussions with the lady. Is that right?
Yes.
And the lady told you that if you wanted to get benefits, you had to mention the names of various people who were implicated, it seems. Well, just remind me what she told you, because I don't have the exact note in front of me. Why did she tell you to implicate these people?
They say that the OTP is concerned with those people about witness interference.
All right. And when you then met with the investigators, you gave them certain reports in which you mentioned these people. Is that right?
Yes, I gave them.
And what you told the investigators about these people, where did that information come from? Did you make that up?
The lady told me that she has been speaking with people who are within the country, and they had given him some information of what that information is now. She said that it was very hard for her to relay the message to the prosecution, because she was not allowed to talk or to speak with people who are within the country. So she told me that it was better for you, since you are inside the country. When you go there, you just go and say, I've seen this and this.
So, firstly, a correction to the record at line 3. It should be within the country, where the word indiscernible appears. Do I understand from that that the details that you told the investigator were relayed to you by the lady?
Some of them.
And the others? What about other details? You say some of them. Where did the other details come from?
Maybe I could request to go over that report just for a while.
Certainly I can give you that opportunity. You can't recall, as you are sitting there, where you might have got other details from that weren't told to you. Sorry, that I'm not finished. That weren't told to you by the lady.
I think my memory should be refreshed, so that I see in details what actually I told them, and say this one was from the lady, this one was mine.
Court will bear with you for one moment, please. Before I call up that statement, I just want to understand you correctly. Is it your version that basically you and the lady conspired to provide false evidence to the OTP in order to get greater benefits? Is that what you're telling us?
Sorry, maybe you can repeat the question. I never got it well.
Yes. Is it correct from what you told the court that you and the lady, and let me use a simpler word, discussed the fact that you would give false details to the prosecution in order that the two of you would get more benefits? Is that right?
Yes.
All right. Mr. Court Officer, can I ask you please to call up the document I mentioned earlier, Ken OTP 01171019 R02.
The first page of that document is being presented to the witness.
Mr. Witness, do you recognize that document?
Yes.
And you confirm it's your name that appears in typed font at the top left and your signature at the bottom of the page?
Yes.
And can we call up the last page, please, Mr. Court Officer, page 1027?
Yes.
You confirm that's your signature below the witness acknowledgement, dated 13 November?
Yes.
And again at the bottom of the page.
Yes.
Does this refresh your memory as to whether this document was in fact shown to you by the VW during your witness preparation?
I was not shown. I only read two statements.
All right. Because I'll check, but according to my records, this... Yes, in fact, my colleague has just confirmed that this witness was provided, this statement was provided to the VWU for the purpose of your witness preparation. Are you sure you didn't see it?
No, I only saw two statements. The one for 6th, 7th, and 8th, and the one for 14th of July. I never read this one.
And Your Honour, can I just for the record state the obvious? The fact that information was given by VW doesn't mean VW gave it to a witness, or that the witness read it.
The fact that information was given to VWU.
It does not mean that VW gave it to the witness, or that the witness read it, to the extent that my learned friend is seeking to make a point of it.
Well, let's leave it there. Mr. Steinberg, continue.
Yes. Well, Your Honours, that is obviously something that can be objectively verified from the VW members present at the court. But it places me in a bit of a tricky situation because the witness claims he has not had time to refresh his memory. Either we can do it the tedious way of me reading through the statement in court, or the witness could be given some time to read through his statement to refresh his memory.
All right. This is how many pages of document? 9 or so?
9 pages, Your Honour.
All right.
It shouldn't take the witness too long.
Do you need the witness to read the entirety of the 9 pages for you to ask your question, or is there a discrete part of the document you can point to the witness to see if that refreshes the witness's memory? Perhaps a line or two or paragraph?
My position is made more difficult by the fact that the witness now has denied the truth of much of this statement and has again stated that parts are correct and parts are incorrect.
I thought your objection, your purpose was to refresh the witness's memory.
Yes.
Does it matter? Does he have to read the whole thing to have a memory refreshed?
Perhaps not, Your Honours. If Your Honours is satisfied that that would be fair to the witness to proceed in this manner, then
we will let's give it a try first. If it doesn't work, then we'll see where else we go from there.
Thank you. Mr. Court Officer, can I then ask you to call up the third page of this document? That's ERN 1021.
The page is being displayed at paragraph 10 onwards.
Yes. Your Honours, I'm going to have to ask some questions which may be identifying of the lady. May I ask that we go into private session, probably for no more than 3 or 4 minutes.
Private session.